let's talk about Gabby Petito, 22 years old. Her story, I think everyone knows that story now. That she was living this van life and wanted to go out and experience things and wanted to post it all on YouTube. Well, she was reported missing September 11th by her family, as you will recall, after her boyfriend slash fiance, Brian Laundrie, returned home from this incredible van life cross-country trip they were taking. He returned in her van on September 1st without her, okay? Then you'll remember the FBI released some information on September 21st, and this was huge information. The search for evidence in a remote area of the Grand Teton National Park and the Bridger Teton National Forest. The Teton County Coroner, Dr. Brent Blue, confirmed the remains are those of Gabrielle Venora Petito. Coroner Blue's initial determination for the manner of death is homicide. So it's a homicide. The evidence was found at the Grand Teton National Park and the Bridger Teton National Forest, right? So take a look. We're in federal land, federal property. Now, we know that Brian Laundrie is already facing federal charges involving the credit card or the debit card that he allegedly was using. Brian Laundrie got an arrest warrant out for him tonight. They're looking for him. But the question is, at some point, hopefully during the course of this investigation, someone will be brought up on some charges relating to the homicide of Gabby Petito. And if in fact the evidence points to this happening on federal property, we could end up in federal court with federal charges. We don't talk about that a lot here on Court TV. Let me put up on the screen. Murder, first and second degree, under our federal statutes. Murder is the unlawful killing of a human being with malice aforethought. Every murder perpetrated by any other kind of willful, deliberate, malicious, and premeditated killing is murder in the first degree. Okay, that's first degree murder. Malicious, deliberate, premeditated. Okay, malice aforethought. Any other murder is murder in the second degree. There's also manslaughter, two types of manslaughter. Let's begin with voluntary. Manslaughter is the unlawful killing of a human being without malice. Okay? Voluntary can happen upon a sudden quarrel or heat of passion. Big words right there. Sudden quarrel, heat of passion, unlawful killing. No malice, but heat of passion. Involuntary manslaughter, in the commission of an unlawful act, not amounting to a felony, or in the commission of an unlawful manner, or without due caution and circumstance of a lawful act which might produce death. That's involuntary manslaughter. Okay, so you got first degree murder, second degree murder, voluntary manslaughter, involuntary manslaughter. Let's take a look at what we know so far and how we would get to any of those charges in the death of Gabby Petito when and if someone is arrested and charged with her death. Let's bring in our think tank tonight. Joining us in New York, New York, former senior homicide prosecutor Bernarda Villalona. In Cleveland, Ohio, criminal defense attorney, law professor at Cleveland State, Ian Freeman is with us. And in San Diego, California, criminal defense attorney, former prosecutor Brian Watkins. You can contact him at brianwatkinslaw.com. Great to see everyone. Bernarda laid out first degree, second degree, voluntary, involuntary. How do you see the death of Gabby Petito? How do we end up? Let's begin with first degree murder. How can you prove that when you just find a body just left out there in the national park?
Exactly, Vinny. Right now, we don't have enough information in order to determine what was the mental state of Laundrie in this killing.
Well, we're not saying it's Laundrie. We're not saying it's Laundrie. We have not accused anyone here. Ian, did I accuse anyone? I didn't accuse anyone, did I?
I didn't hear anything, and I'm glad you corrected it because I was about to jump in.
For whoever is held responsible, what would they have to show to get us into first-degree murder in this case?
So in order to get us into the realm of first-degree murder, we have to see that there was some kind of probably premeditation, that there was some kind of planning, that this was well thought of. And as of now, we don't have any information in that regard. We don't even have a cause of death. If we were to have a cause of death, maybe that she was shot in the head or there were multiple wounds, maybe you can argue because of the number of wounds that was more of a first-degree murder type case. But as of now, Vinny, we don't have enough information to determine what actually happened. We don't even have a cause of death.
We don't yet, but you're putting us in a place. Okay, so if it turns out she died from gunshot wounds, that would lean more towards first-degree murder. Ian Freeman, how do we land in second-degree murder in a case like this?
Without that malice of forethought, you would get down to the second degree. But let me just be clear. Whether it's 1, 2, manslaughter, at this moment, none of those things exist. Now, of course, none of the four of us have all of the information that the law enforcement has been gathering. So we only know a fraction of the story. But the defense lawyer in me says we've got to go on a real slow roll here because people always jump to conclusions. We don't know at this moment whether there was a criminal act, whether it was an accident, whether Laundrie or anyone else is scared to come forward. Nobody knows.
Well, we know it's,
so
wait, prosecutors believe, and their expert believes it's homicide. So what would be a non-criminal homicide here? Self-defense? Was Gabby Petito attacking someone and someone had to defend themselves?
No, but if they're hiking, somebody falls. If he falls into it, it's an accident. Something like, we don't know.
But that would be accidental. That wouldn't be homicide.
I get it. And I have been in many, many murder cases where the original finding of death didn't turn out to be what it was at the end of the day. So just because it's on a piece of paper here on minute 1, before we've heard anything else or seen the evidence to back it up, I can't go as the defense lawyer and agree with it.
No, you don't have to agree with it. I'm wondering how prosecutors get there, okay? Once prosecutors get there, then we'll see how the defense responds to that. But right now, the defense does nothing because there's no one defending anything because no one's been charged. So how do we get to step 1? So I'll go to Brian Watkins. I'm looking here, former prosecutor. All right, Brian Watkins, let me ask you. Ian's not the former. You're always defense, right, Ian?
I'm always defense.
Always. Okay. I put you in a bad spot. My bad. Let's go to Brian Watkins. Where is he? Right here, right here. Go ahead, Brian. Former prosecutor. Let's talk about the manslaughter. How would you prove that? What would have to happen? What is this sudden quarrel or heat of passion?
Well, that's an easy one to get to. You know, I mean, if there was a fight between the two, if he says that she came at him in any way, shape, or form, and he did something that caused her death, then you're in manslaughter bail. But one of the problems he's going to have is that now he's taken to flight. He's fled. And flight is consciousness of guilt. So any sort of innocent explanation for her death is out of the window right now, because if she fell down hiking like Ian suggested, he wouldn't have fled. He'd be talking to the police. He would have called police. Help me, my girlfriend fell down. She's hurt. So now we have his flight, and it's going to be very difficult to come up with any other scenario other than murder. Don't forget, we charge people where we never even find the body, where the person just goes missing, a.k.a. Robert Durst. Okay, his wife was never even found. So, you know, the matter of death is not really that necessary. Like I said, they don't even need to have found the body to charge a person with murder.
Now, here's why this is so important, because I'm looking at the penalties for these different crimes. Take a look, folks. First-degree murder, death or life. Second-degree murder is like up to life. So there's a lot of flexibility there. Voluntary manslaughter drops all the way down to up to 15 years. Involuntary, up to 8 years. And again, this is for the death of a human being. So there's a lot at stake here. We still, have a lot to learn factually, and investigators are still trying to figure out. No one's been named a suspect. No one's been charged. But we're hoping that someday someone will, because that means that investigators are solving the crime. Now, got some more information for you. Today in the search for Brian Laundrie, new information coming out that Brian Laundrie's sister, Cassie, has seen him since his return to Florida on September 1st. Cassie Laundrie previously told ABC News in an interview she has not spoken to Brian since he got back from his cross-country trip.
I haven't been able to talk to him. I wish I could talk to him.
Now, today, Stephen Bertolino, the Laundrie family attorney, gave this statement to Court TV. The last time Cassandra Laundrie saw Brian was on September 6th. Law enforcement agencies are well aware of these dates. Any prior communication by Cassie does not reflect these dates, is simply a difference of relating an answer to a question misinterpreted by Cassie or poorly posed by the inquirer. That is great lawyer talk. That is great lawyer talk. But the bottom line here, let me bring back in the think tank. All of a sudden now you've got Cassie, who is with Brian Laundrie on the 6th after he returns. What's her role in all of this? And I'll start with you, Bernarda, former homicide prosecutor. Do prosecutors want to talk to Cassie? Does she need a lawyer? Does she have the right to just remain silent in all this? Because apparently she was with her brother September 6th, which is that weekend where the family took the camping trip down at Fort DeSoto.
So, Vinny, we already know everyone has a constitutional right of their Fifth Amendment right against self-incrimination. So they all have the right to remain silent. However,
but explain this to me. And I'm going to interrupt you for just 1 second, okay? Because I'm going to let you finish. But I just have to go to Ian quickly. Ian, explain to me this Fifth Amendment right against self-incrimination. Do you have to, have done something wrong? Because I don't think the sister's done anything wrong, but what if she's just a witness or heard a confession or heard some information about where he could be? That's not incriminating. You have a Fifth Amendment right to not even give that information?
Yeah, so there's always this misconception that if someone takes the Fifth, they must have done something wrong. That's a part of it. You are exercising your right not to give a statement, not just because you're hiding something like people think, but sometimes you don't know what the situation is, and you don't want to interject yourself into a situation of unknowns where you could inadvertently be looked at, scrutinized, or suspected. So we as lawyers, when someone says, I don't know what to say, should I say anything? Remain quiet at that point. An old mentor of mine used to say, even a fish cannot get in trouble if it keeps its mouth shut. And that's exactly what we see here. This woman, I don't know what she knows, doesn't know, but the Fifth Amendment does not just protect the guilty. It protects the innocent from getting into trouble by accident, even when they are well-intended. That's why it is there. It is there for all of us, not just defendants.
That's not necessarily true. That's not necessarily true. We're talking here about
we're going to disagree on this one, but I want to hear this.
Well, here, we're talking about federal prosecution here. And you can get subpoenaed, and you have to talk. You don't have the right to plead the Fifth. You have to answer their questions. The court will order you to answer their questions. And if you don't answer questions, you're held in contempt and can go to jail for up to 18 months. So she can be forced to testify. If she is not a target, if she is not a defendant, yes, they can compel her to testify and answer questions in front of a grand jury.
Brian, you're correct, but we're a couple steps out. We're talking now about people not taking statements. You are correct that once we get into court and once the government makes declarations and once the court then makes findings, you're in a different place with contempt. That's correct. I'm at step one. You are correctly at step three.
Okay, all right.
So we're saying the same thing here.
Saying the same. All right, Bernard, I'll let you finish this up right now. Go ahead.
So just to add, one thing that the prosecution has, a tool that they use all the time, is that if they determine that a witness is material, has material information in any kind of investigation or at the time of trial, they can request the judge to issue a material witness order and compel that person to be taken into custody in front of a judge and compelled to speak. However, the prosecutor will have to have a good faith basis and knowledge that the information that they have is material.
All right. That's why we have them on the show, folks. Nobody else is talking about this. No one else gets into the level of depth and experience that our guests have and the issues that everyone else just avoids. Not here on Court TV.